Hello, everyone. Welcome to Court with Krissy. We've got a victim here who wants to put a statement on the record, and it's only her abuser's plea. We're not even at sentencing. And for someone who came to talk, I'm surprised she kept as quiet as she did, although I think I heard an F-bomb. This one's good. I hope you like it. Court with Krissy's now in session.
So, ma'am, this case is being live streamed. You okay up here and on camera with your bonnet on? I know we're in a bonnet culture where everybody seems to wear their bonnet for every situation, but at some point, is there a period of time where the bonnet comes off and you actually fix your hair to look like you got something going on? Okay. This is Mr. Brooks, Anthony Lamar Brooks. Mr. Brooks is before the court 2025 CR 00021 for simple battery, family violence count 1, and simple battery count 2. Mr. Brooks is also before the court on 2025 CR 00998 for battery, family violence count 1, battery count 2, simple battery, family violence count 3, and simple battery count 4. Mr. Brooks is represented by the law firm of Lister Holton Dennis. Mr. Taylor is with him at the podium. Mr. Taylor, Mr. Brooks, raise your right hand for me.
Raise your hand.
Do you solemnly swear or affirm any testimony that you give in this matter will be true?
Yes, ma'am.
All right, and you can put your hand down. Mr. Taylor, what is your client plead to the offenses before the court on the case ending in 2-1?
Your Honor, before we enter a plea, the alleged victim in the case, Mrs. Brooks, is online before the court. I believe she'd like to address the court concerning this matter. She's unable to speak with the victim advocate because there's a conflict. However, I think she wishes to address the court on the specific case.
Your Honor, the state would just object. I mean, we're in the middle of a plea, so.
Object. Okay, hold on, Ms. Hagler. I don't know what you're objecting to.
Well, Your Honor, I mean, we're in the middle of a plea, and so for Attorney Taylor to want to hear from the victim, I mean, is the defendant pleading or is he not pleading? I mean, unless does she wish to make a statement in open court about the case? I mean,
she does. She wishes
to
make a statement on the record.
Your Honor, the state would object to allowing the victim at this time in this case to make a statement to the court prior to the defendant taking the plea, in which the victim is entitled at that point to make a victim impact statement. It would just be inappropriate for, it appears that, it could be the wrong assumption that counsel is trying to pre-try the case with the court prior to the plea negotiation. Now, if there's anything that she would like to address to our office or provide, but I think at this time, at this phase of the plea, it would be inappropriate for her to make any statements.
Yeah, so if this was a trial, then she could be put on trial at the appropriate time. This is a plea, which means that the plea and then the impact statement. And so I'm not sure why we would deviate in this case.
So, Your Honor, our situation is such that she's here to make a statement before the court concerning the factual basis of the case. And the victim advocate, who is typically the person that's responsible for contacting the victim to find out what happened and how they would like how they'd like to see the case proceed, is unable to contact Ms. Brooks because my understanding is she has something pending.
Objection, Your Honor. I'm going to object to counsel's statement to the court. I would appreciate if Your Honor, there's an objection that the state has, and I would like to have a basis for my objection.
Hold up. We're not deviating from the way we usually do this. Number one, if she wants to make an impact statement, then she can make it after he makes his plea. But let's go here and go with the plea. He got 2 cases back to back. If we're going to make a plea, make a plea. If not, let's move this to the trial calendar and keep it pushing.
Thank you,
Your Honor. Therefore, in that case, we'll be entering a not guilty plea.
All right.
We'd like to be heard on bond.
Okay, well, what does he not have a bond?
He does not have a bond on case.
Why did they no bond him?
Well, Your Honor,
He was
go ahead.
he was charged, and it's my understanding, and either Ms. Hager or Mr. Taylor can correct me if I'm wrong, he did not receive a bond on the battery family violence case because he has another open case for this similar offense against the same victim. So that's why he doesn't have a bond. And for this, because there is a victim in this case, Your Honor, the state would ask for this court to instruct counsel to file appropriate motions for this particular case. Essentially, for this misdemeanor battery family violence, it's not as he's entitled because it's a misdemeanor. When family violence is for this particular charge, he's not technically entitled to a bond because he has another case outstanding against the same victim.
Your Honor, and Ms. Brooks would like to be heard on the matter of bond as well for her husband.
All right, hold on a second. Okay, so it appears that Mr. Brooks was denied bond under 1710(1) 3B. The court is going to grant a hearing for bond, but it's not going to be today.
Yes, Your Honor.
So file your motions so that the state can be put on notice as to what they need to consider. And then once the motions are filed, the court will grant a date for hearing. But just because, Mr. Taylor, you know how this works. Every victim of domestic violence or alleged victim of domestic violence, 8 out of 10 of them at some point come in begging to have the person released. And that's why the laws change. And that's why we have all of these things that allow us to consider how to maintain safety and to keep people from being violent. But when I got 2 back-to-back cases, it's not looking good for Mr. Brooks to be out. The magistrate court did what they did by no bonding him. I can consider it, but I'm not going to rush it because I don't see a rush in this case.
Well, Your Honor.
What am I rushing for? I got 2 back-to-back.
I understand, Your Honor, and that's why I wish Ms. Brooks to speak regarding the family's financial concerns, which is one of the factors.
Mr. Taylor, that is one of the financial concerns is one of the aspects of domestic abuse. The domestic abuser controls the finances, so that's why it determines what happens. And so, no, I don't care, Ms. Brooks. I don't care. That is not a factor that I'm going to consider right now. If Mr. Taylor wishes to go ahead and file his motions, then I'll hear the motions, but I'm not rushing a consideration of bond on somebody who's got 2 pending violent misdemeanors. No. So file the motions. It will go through the normal course. We'll set them for hearing when the time is appropriate. Otherwise, it is what it is. I'm not being harsh, but I'm not rushing to do something for somebody in an extraordinary fashion when the law says everything's been done the way it's supposed to be, and the law requires a written motion, and then you file your motion. The state has time to consider, especially in a case where I already have an implication that it is possible Mr. Brooks will commit another violent offense while out. Back-to-back offenses at least give me that under the Ayala factors. And so I'm not rushing this. Mr. Taylor, file the motion.
Thank you, Your Honor.
All right, we'll accept the not guilty. You can go back with the sheriff's office. And it is my understanding that we have concluded this calendar. Is there anything else outstanding that I need to consider? Otherwise, I'll be signing.
Nothing from the state, Your Honor.
All right, thank you.
See you on Thursday.
Have a good day.
All right, take care.
You too. Bye.
Or tomorrow.